It often takes months for parties and their attorneys to work out the terms of a divorce. The divorce hearing itself typically takes 10 or 15 minutes, but once the divorce is finalized, things still must be accomplished in order to make certain that the terms of your divorce settlement are actually implemented as you want them to do. There are certain things that I really recommend be done at the time of the divorce judgment itself. One of the first things I like to accomplish is make certain that if there's a transfer of real estate, that the quitclaim deed is signed. Typically that should be signed on the day of divorce hearing so that the parties don't have to chase each other around to make certain that things are signed. The same is true for titles for vehicles and boats and the like. After the divorce is finalized, another thing that must be accomplished is make certain that the health insurance is taken care of properly. The insurance company doesn't know that just because a divorce has occurred, that is being done. So if you have to add a person to the policy or take someone off the policy, that should be done so immediately. Just because you are divorced, you may assume that your ex-spouse is removed from a beneficiary designation on a life insurance policy or a will. That's not true. While there is a law in Wisconsin where there is a presumption that upon a divorce, the spouse is removed from the policy, that is not automatically accomplished, nor should be assumed. The better practice is to notify the insurance company in writing if you wish to change beneficiaries, or if you still want your ex-spouse to be a beneficiary under your policy. This can prevent lawsuits in the future. I've been involved in those type of lawsuits in other cases. They're very expensive and difficult for the family. Let's talk next about one of the larger assets in most divorces, which are the retirement plans. In order to divide a retirement plan, you must have a qualified domestic relations order prepared. Typically, either one of the attorneys or an expert in the area will prepare the document, but the parties must make certain that it is done in a timely manner. You should also take the necessary steps to divide and close any bank accounts or credit accounts in which you and your ex-spouse are still named. I strongly recommend you consider either starting a will or a trust or amending your current will and trust to make certain that your minor children are taken care of. You need to designate guardians in case you die early and when they're minor, and if your ex-spouse is no longer available to take care of them. And the trust is necessary in order to make certain that your children's financial needs are taken care of until they are old enough to take care of them themselves. I wish you and your family the best of luck, and if you have any questions, please feel free to give me a call at 283-6737.